Before we begin, a quick and important disclaimer. I am not a lawyer, and this presentation is not a substitute for legal advice. The information provided here is for educational and informational purposes only. Real estate laws vary significantly by state, county, and even city. You should always consult with a qualified, licensed attorney in your jurisdiction for advice on your specific situation. This video is intended to help you ask the right questions, not to provide the answers for your individual transaction. They found it. The perfect house. A 4-bedroom colonial with a wraparound porch, a tire swing in the backyard, and a kitchen that looked like it was ripped from a magazine. Let's call them Mark and Jessica. For 2 years they'd sacrificed everything. They skipped vacations, drove a 10-year-old car, and ate more ramen noodles than they'd care to admit. All for the down payment. And now, sitting at their kitchen table, staring at a mountain of paperwork, it was all about to pay off. Their real estate agent, a friendly guy named Bob, slid the purchase agreement across the table. "It's a standard contract," he said with a reassuring smile. "Just sign here, here, and here, and the house is yours." Their hands were shaking with excitement. They barely skimmed the pages. Words like easement, title contingency, and indemnification swam before their eyes. But they trusted Bob. He'd found them their dream home after all. So they signed. 6 months later, the letters started arriving. Official-looking envelopes from something called the Hampton Creek Watershed District. Apparently, their beautiful backyard, the one where they imagined their kids would play, was situated on a protected conservation easement. They couldn't build a fence. They couldn't plant a garden. They couldn't even remove a dead tree without a board approval process that took months. The tire swing, technically a violation. That wraparound porch they loved so much? It encroached on the property line by 6 inches, a problem the previous owner had conveniently never disclosed, and the standard contract did nothing to protect them from. Their dream home had become a legal prison, a financial black hole of restrictions and potential lawsuits. A problem that a $700 attorney would have spotted in less than an hour. A problem their real estate agent, Bob, legally couldn't and didn't have the expertise to identify. This isn't just a horror story. It's a quiet catastrophe happening to thousands of American families every single year. And it all stems from a massive, dangerous misunderstanding about who is actually on your side when you buy a house. So let's ask the question head-on. Do you really need a real estate lawyer to buy a house in the United States? The answer isn't a simple yes or no. It's one of the most consequential and least understood questions in personal finance. And by the end of this video, you will not only know the definitive answer for your specific situation, but you will be armed with the knowledge to protect yourself from the single biggest financial mistake you could ever make. We are going to demystify the entire process. We'll break down exactly which states legally require an attorney and why. We will expose the critical and often invisible legal risks your real estate agent is not qualified to handle. And we'll give you a simple checklist to determine if hiring a lawyer is the smartest $1,000 you'll ever spend, or a complete waste of money. Let's start with the most fundamental truth, the one that the real estate industry doesn't exactly advertise on billboards. Your real estate agent is a salesperson. A highly skilled, incredibly valuable salesperson, but a salesperson nonetheless. Their primary mission is to facilitate a transaction. They are experts in marketing, pricing, negotiation, and navigating the local market. They are the matchmakers who introduce you to your future home. But here is the critical distinction. Their goal is to get the deal to the closing table. That is how they get paid. Their commission is directly tied to the successful sale of the property. An attorney, on the other hand, has a completely different job. Their job is not to sell you a house. Their job is to protect you. Their one and only allegiance is to your legal and financial interests. They have what's called a fiduciary duty to you, which is the highest standard of care in the law. They are paid a flat fee, not a commission. This means they have zero financial incentive to push a deal through if it has hidden risks. In fact, their entire professional reputation and license to practice law depends on their ability to find and neutralize those risks before you sign on the dotted line. Think of it this way. Your agent helps you fall in love with the house. Your lawyer makes sure that love doesn't leave you bankrupt and heartbroken. The agent hands you that standard contract. It looks official. It's full of boilerplate language. But what does standard mean? It means it's a template designed to be broadly acceptable to buyers and sellers to keep deals moving. It is not a document that has been custom-tailored to protect your unique interests. Can you add a clause that says the purchase is contingent on you getting approval from the city to build a fence for your dog? Yes, but your agent can't write that clause for you. That would be the unauthorized practice of law, and they could lose their license. They can only use pre-approved, fill-in-the-blank clauses. A lawyer, however, can draft bespoke language from scratch that creates an ironclad escape hatch for you if your specific needs aren't met. That is a world of difference. Now, for millions of Americans, this debate is already over before it begins. In 21 states and the District of Columbia, the law explicitly says you must use a real estate attorney for your closing. It is not optional. It's not a suggestion. It is a legal requirement. These are often called the attorney states. If you are buying a home in any of the following states, you don't have a choice in the matter, so listen closely. The states are Alabama, Connecticut, Delaware, the District of Columbia, Florida, Georgia, Kansas, Kentucky, Maine, Maryland, Massachusetts, Mississippi, New Hampshire, New Jersey, New York, North Dakota, Pennsylvania, Rhode Island, South Carolina, Vermont, Virginia, and West Virginia. If you live in one of those states, your decision is made. You need a lawyer. But why? Why do these states mandate it? It's because they have legally defined certain parts of a real estate transaction as the practice of law, and only a licensed attorney can legally perform them. The most important of these tasks is the title search and examination. Before you buy a house, you need to know that the person selling it actually has the legal right to sell it, free and clear of any other claims. A title company performs a search of public records to create a history of the property. They look for things like old mortgages that were never paid off, tax liens from the IRS, unpaid contractor liens, or even a long-lost heir who might have a claim to the property. The title company provides a report, but in these attorney states, only a lawyer is legally permitted to read that report, interpret its findings, and advise you on the legal consequences. Is there an old utility easement that gives the power company the right to dig up your new lawn whenever they want? Your lawyer will find it and explain it. Is there a messy divorce from 30 years ago that clouds the title? Your lawyer will tell you how to resolve it before you close. They are your legal detective, uncovering the hidden history of the property that could become your future nightmare. The second reason is document preparation. The deed, the mortgage documents, the closing statements. These are complex legal instruments. In attorney states, a lawyer is required to draft, or at least review these documents to ensure they are accurate, and that your rights are protected. They make sure the legal description of the property is correct down to the inch. They ensure the terms of your loan match what the bank promised you. This is your last line of defense against clerical errors and predatory clauses that could cost you tens of thousands of dollars down the road. Finally, in many of these states, the closing itself must be conducted by an attorney. This isn't just a formality. The closing attorney sits at the table with you and explains every single document you are signing. You have a legal expert right there, ready to answer your questions in real time. What does this paragraph mean? Why is this fee on the statement? The attorney is your advocate in the room, ensuring the entire process is handled correctly, legally, and ethically. In these 21 states, the law has decided that the risks are simply too high to let consumers navigate this legal minefield alone. The cost of the attorney is just a built-in, non-negotiable part of ensuring a safe and legal transfer of property. But what about the other 29 states? The ones where the law essentially looks at the biggest financial transaction of your life and says, "Good luck, you're on your own." This is the world of so-called escrow states or title states, places like California, Texas, Florida, and Arizona. And this is where the question of needing a lawyer stops being a legal requirement and starts being a high-stakes, personal calculation of risk versus reward. In these states, the closing process isn't run by lawyers. It's handled by a neutral third party, typically a title company or an escrow company. Their job is to hold the money, perform a title search to make sure the seller actually has the right to sell the property, and file the final paperwork. Think of the title company as the referee in a high-stakes game. They make sure the money goes from the buyer to the seller at the exact same moment the deed goes from the seller to the buyer. They ensure the basic rules of the game are followed. But here's the critical part they don't tell you in the brochure. The referee is not your coach. They are not on your team. They won't advise you on strategy, they won't point out weaknesses in your contract, and they won't warn you if you're about to make a catastrophic, game-losing mistake. Their legal duty is to the transaction itself to remain neutral. Your real estate agent is your coach for finding the house and negotiating the price. But they are not a lawyer. If you ask them to interpret a complex legal clause in the contract, They are legally and ethically barred from doing so. So in these 29 states, you can walk into the biggest deal of your life, surrounded by professionals, and have absolutely no one in the room whose sole, undivided legal responsibility is to protect you. To understand what that really means, let's talk about David and Jessica. They were buying their first home in a booming Austin, Texas suburb. It was a beautiful 4-bedroom house with a huge backyard, perfect for their 2 kids and their golden retriever Buddy. They were in an escrow state. They had a great agent, a friendly loan officer, and the title company was a big, reputable firm. Everyone told them, "You don't need a lawyer here, it's an unnecessary expense. The title company handles everything." It sounded great. Saving $1,000 felt like a smart move when they were already stretching their budget to the max. They found the perfect house, beat out 3 other offers, and went under contract. The purchase agreement was a standard Texas state-promulgated form. It was 12 pages of dense, single-spaced text. Their agent walked them through the main points: price, closing date, financing contingency. It all seemed straightforward. They initialed here, signed there, and sent in their $5,000 of earnest money. They were ecstatic. A few weeks later, they got the title commitment. It was a thick packet of documents from the title company, basically saying, "We've searched the public records, and here's what we found about the property's history." Buried deep inside was a section called Schedule B, Exceptions to Coverage. It was a list of things the title insurance policy would not cover. On that list was a reference to a document recorded in 1987, described simply as a restrictive covenant. David and Jessica glanced at it. Restrictive covenant. Sounded like boring legal jargon. They figured it was just standard stuff, probably something about not being able to build a skyscraper in the backyard. The title officer couldn't explain what it meant. That would be legal advice. Their agent couldn't either. They were on a tight timeline, the clock was ticking on their inspection period, and they didn't want to spend money on a lawyer just to look at some old piece of paper. So they did what most people do. They shrugged, assumed it was fine, and moved on. The inspection went well, the appraisal came in at value, and their loan was approved. Everything was smooth sailing. They were 2 days from closing, their boxes were packed, the moving truck was booked. Jessica was on the phone with a fencing company, getting a quote to build a fence for Buddy in their huge new backyard. It was the main reason they fell in love with the house. The fence guy put her on hold for a minute, then came back on the line. "Ma'am," he said, "I'm looking at the plat map for your property. Are you aware of the utility easement running along your back property line?" Jessica had no idea what he was talking about. He explained that a 15-foot wide strip along the entire back of the yard was designated as an easement for public utilities. No permanent structures could be built there. No fence, no shed, no pool, nothing. That huge backyard, the one they'd been dreaming of, was effectively 15 feet smaller. The fence they had planned was now impossible. Panic set in. They called their agent, who was just as shocked as they were. They dug out the title commitment. The easement wasn't mentioned on the exceptions page. So where did it come from? They finally got a copy of that restrictive covenant from 1987. It wasn't a single document. It was a 50-page declaration for the entire subdivision. And on page 42, in a paragraph of dense legalese, it not only described the utility easement in detail, but it also contained another little surprise. It stated that no home in the subdivision could be used for any business purpose that involved customers visiting the property. This was a disaster. David was a freelance graphic designer, but Jessica was a music teacher who taught piano to a dozen students out of their home. Her income was a critical part of their budget, the very income they used to qualify for the loan. In the span of an hour, their dream home had become an unfensible, unworkable nightmare. They wanted out, but they were 2 days from closing. They called the title company, frantic. The polite but firm response was, "We can't give you legal advice. Our commitment disclosed the existence of the restrictive covenant. It is the buyer's responsibility to review any such documents." They called their agent. He felt terrible, but his hands were tied. He said, "If you back out now, the seller will almost certainly keep your $5,000 earnest money, and they could even sue you for breach of contract to try and force you to buy the house." David and Jessica felt the walls closing in. The $1,000 they'd saved by not hiring a lawyer now seemed like a cruel joke. They were facing a choice from hell. Either lose $5,000, plus the money they'd spent on the inspection and appraisal, and end up with no house, or be legally forced to buy a home where Jessica couldn't legally work, and they couldn't build the fence that was the centerpiece of their family's dream. They were trapped. In a transaction involving $500,000 of their money, they had no advocate. The seller's agent was fighting for the seller. The title company was neutral. Their own agent was powerless. This is the hidden risk of an escrow state. It's not about the process failing. The title company did its job. The agent did their job. The system worked exactly as it was designed to. But the system is not designed to protect you. It's designed to transfer property. A real estate attorney's job is different. Their duty isn't to the transaction, it's to their client. An attorney would have received that title commitment and their first action would have been to pull and read every single underlying document referenced. They would have read the 50-page restrictive covenant. They would have immediately flagged the business use restriction and the easement. They would have explained the legal and practical implications to David and Jessica. This would have happened during their inspection period, giving them the power to legally terminate the contract and get their earnest money back, no questions asked. A $1,000 investment would have saved them from a $50,000 mistake, not to mention the emotional devastation. Instead, they were left alone, holding a contract that was a ticking time bomb, with no one to help them defuse it. Their story isn't a rare one-in-a-million horror story. It's a quiet, everyday tragedy that plays out in countless transactions across the country, all because of the seemingly innocent decision to save a little money by going it alone. So let's pull back the curtain on the entire home buying process. When you decide to buy a house, you're told you're assembling a team. You have your real estate agent, your mortgage lender, your home inspector, and the title company. It sounds collaborative, supportive, like everyone is rowing in the same direction with your best interests at heart. But this is one of the most pervasive and dangerous misconceptions in real estate. The truth is, you're not the captain of a team. You're the center of a complex ecosystem where every other player has their own distinct, and often conflicting, financial incentive. And none of their primary incentives are to protect you legally. Think about your real estate agent. A great agent is a godsend. They know the market, they can find hidden gems, and they can be a brilliant negotiator. But let's be brutally honest about their motivation. They are a salesperson. They get paid a commission, typically a percentage of the sale price, and that commission is 100% contingent on the deal closing. If the deal falls through for any reason, even a very good reason that saves you from a financial nightmare, they get nothing. Zero. All those hours showing you houses, writing up offers, all for nothing. This creates an inherent, unavoidable conflict of interest. Their financial well-being is directly tied to getting you to the closing table. Is it in their interest to point out a vague, potentially problematic clause in the contract that might spook you and cause you to back out? Or is it in their interest to say, "Oh, that's just standard boilerplate, don't worry about it," and keep the transaction moving forward? Even the most ethical agent in the world is fighting against this powerful financial gravity. They are your guide and your market expert, but they are not your legal guardian. Then there's your lender, the bank or mortgage broker. Their role is even more clear-cut. They are not on your team, they are your business partner in the most literal sense, and they are the senior partner. Their job is to assess risk. First, is the house itself valuable enough to serve as collateral for the massive loan they're giving you? That's why they order an appraisal. Second, are you financially stable enough to make the payments for the next 30 years? That's why they scrutinize your income, your debt, and your credit score. They are protecting their money, not your lifestyle or your future happiness. They couldn't care less if the foundation has a crack or if the zoning laws are about to change next door. As long as the house appraises for the loan amount and you're likely to pay them back, their job is done. They are not your financial advisor. They are the bank. And what about the title company? This is the one that confuses most people. The name itself, title company, sounds official and protective. They perform a title search to make sure the seller actually has the right to sell the property and that there are no old liens or claims against it. They issue title insurance, which protects you and the lender against problems with the title from the past. This is a critical function, but it's also a very narrow one. The title company is a neutral third party, a facilitator. Their job is to follow the instructions in the purchase contract and manage the paperwork to ensure the title transfers correctly. They will not read your contract and advise you on its terms. They will not negotiate on your behalf if a dispute arises. They will not point out that your inspection contingency is weak. Their role is transactional, not advisory. They are the meticulous scorekeeper of the game, not your coach. So you have a salesperson who needs the deal to close, a bank that's only protecting its own money, and a paperwork facilitator who remains strictly neutral. Who, in this entire constellation of professionals, has a single solitary obligation, a legal, ethical, and professional duty, known as a fiduciary duty, to protect your interests and only your interests, with no conflicting incentives. Only one person, your attorney. A lawyer doesn't get a commission. They typically work for a flat fee or an hourly rate. Their payment isn't contingent on the deal closing. In fact, a lawyer is often the only person at the table who might get paid for telling you not to buy the house. Their sole function, their only success metric, is ensuring you are protected. This fundamental difference in roles is so critical that the United States is literally split in two over it. There's an invisible line that divides the country into what are known as attorney states and escrow states. In attorney states like New York, Massachusetts, Georgia, and the Carolinas, state law requires a real estate attorney to be involved in the transaction, usually to handle the closing. The state legislatures in these places looked at the complexity and the high stakes of a real estate deal and decided that a buyer's interests could not be adequately protected without independent legal counsel. They made it mandatory. But in the majority of states, including huge markets like California, Texas, Florida, and Arizona, they are escrow states. In these states, an attorney is not required. Closings are handled by a title or escrow company, and this is where the danger really lies. The risks inherent in a real estate transaction don't magically disappear when you cross the border from Georgia into Florida. The contracts are just as complex, the potential for disputes is just as high, but the mandated legal safety net is gone. This creates a massive false sense of security. People assume that if a lawyer isn't required, then one isn't needed. They follow the standard process, put their trust in their agent and the title company, and never realize they're walking a tightrope without a net until it's far too late. Let's get specific. Let's talk about the single most important document in the entire process: the purchase agreement. This is the legally binding contract that dictates every single term of the sale. In most transactions, the agent pulls out a standard form contract. It's usually a 10 or 12-page document created by the state or local association of realtors. The agent fills in the blanks: your name, the seller's name, the price, the closing date. And because it says standard form at the top, everyone treats it like it's gospel. But standard does not mean safe. Standard does not mean optimized for your protection. Standard simply means one size fits most. And it's a size designed by the real estate industry, for the real estate industry, to make transactions as smooth and efficient as possible. It's designed to get deals done. It is not designed to shield you from the thousands of things that can go wrong. When you hand that standard contract to a real estate attorney, they see something completely different. They aren't just checking the spelling of your name. They are stress testing every single clause. They're looking for the loopholes. They're identifying the ambiguities. For example, the inspection contingency. The standard clause might say you have 10 days to perform an inspection and can cancel the contract if you're not satisfied. Sounds good, right? But what if the inspection finds a $15,000 problem with the sewer line? You love the house and don't want to cancel. You want the seller to fix it or give you a credit. But the standard language may not give you that right. It might be an all-or-nothing proposition. Take the house with the $15,000 problem or walk away. An attorney would immediately spot this. They would add a rider, a custom-written addendum to the contract with a sentence like, in the event the buyer's inspection reveals defects costing an aggregate more than $1,000 to repair, the seller agrees to either repair said defects prior to closing or provide a credit to the buyer for 110% of the estimated repair cost. Should the seller refuse, the buyer may terminate this contract, and the earnest money deposit shall be returned in full. Do you see the power in that? That one sentence, crafted from years of seeing deals go sideways, completely changes the dynamic. It gives you leverage. It gives you options beyond just take it or leave it. Your agent can't write that clause for you. That would be the unauthorized practice of law. The title company can't suggest it. They have to remain neutral. Only your own lawyer is looking at the board and thinking 3 moves ahead on your behalf. They transform that standard one-size-fits-all t-shirt of a contract into a bespoke, armored suit, custom-fitted to your specific situation, protecting your weak points before you even knew you had them. The most expensive problems in real estate don't come from the issues you can see like a leaky faucet. They come from the invisible risks buried in the fine print of a contract you signed without fully understanding. And the single most important document where these invisible risks hide is the one most buyers spend the least amount of time on: the purchase and sale agreement. You might call it the purchase offer, the contract of sale, or something similar. But whatever its name, This document is not a formality. It is the entire legal blueprint for the biggest financial transaction of your life. It dictates every right you have, every obligation you're bound to, and every single escape route you can take if things go wrong. A real estate agent will hand you a standard, pre-printed form, often 10 to 20 pages long, full of dense legal jargon and say, just sign here, here, and here. But a lawyer doesn't just see a form. They see a battlefield. And every blank line, every checkbox, every clause is a potential landmine. Let's talk about contingencies. These are the most powerful words in a buyer's vocabulary. A contingency is basically an if-then clause that lets you walk away from the deal and get your deposit back. The most common are the inspection contingency, the financing contingency, and the appraisal contingency. They sound simple, right? I'll buy the house if the inspection is okay. I'll buy it if the bank gives me a loan. But the devil is in the details, and those details can cost you tens of thousands of dollars. Imagine this scenario. You're in a hot market. The seller has multiple offers. Your agent, trying to make your offer more attractive, suggests you shorten your inspection period from the standard 10 days to just 3 days. It seems like a smart, competitive move. You get the house. You're ecstatic. You scramble to find an inspector on short notice. He does the inspection on day 2 and gives you the report on day 3. It looks pretty good, but he mentions some minor settling in the foundation and recommends a structural engineer take a look, just to be safe. But your 3-day window is about to close. You can't get an engineer out there for another week. So you have a choice. Do you back out of your dream home based on a hunch and lose it forever? Or do you push forward hoping it's nothing? You roll the dice. You close on the house. 6 months later, you discover that minor settling was actually a massive structural foundation issue. The repair cost? $50,000. A lawyer would have never let that happen. They would have seen the 3-day window and immediately recognized the trap. They would have advised you to negotiate for a longer period, or better yet, they would have written a custom clause into the contract. Something like, buyer has 3 days for an initial general inspection. If said inspection recommends further evaluation by a specialist, such as a structural engineer or electrician, the contingency period shall automatically extend for an additional 7 business days to allow for such evaluation. Boom! With just one sentence, a lawyer builds you a safety net. Your agent's goal was to win the bidding war. Your lawyer's goal was to make sure you didn't win a catastrophe. Their incentives are different. Now let's talk about something even scarier. The title. When you buy a house, you're not just buying the wood and the drywall. You're buying the title to the property, which is the legal right of ownership. You want a clean title. But sometimes titles are clouded. A cloud could be an unpaid tax bill from a previous owner, a contractor who put a lien on the house because they were never paid for that new kitchen, or an old, forgotten mortgage that was never officially discharged. It could even be a surprise heir from a will 2 generations ago, who technically still has a claim to the property. These are invisible problems that won't show up in any home inspection. A title insurance company is supposed to catch these things, but they're not your personal attorney. Their job is to assess risk for the underwriter, not to proactively solve your specific legal problems. A real estate lawyer does a deep dive. They don't just accept the title report at face value. They scrutinize it. They ask questions. They might discover a strange easement that gives your neighbor the legal right to build a driveway straight through your backyard to access a public road. Or they might find a restrictive covenant from the 1950s that says you can't build a fence, or you can't operate a business from your home. A disaster if you're a freelancer. These are deal breakers that a standard title search might list, but not explain the devastating real-world consequences of. A lawyer connects the legal jargon to your actual life and tells you, hold on, this is a bigger problem than it looks. And then there's the closing date. In most contracts, there's a little phrase, just 4 words long, that can be absolutely terrifying. Time is of the essence. It sounds innocent, like something to keep the process moving, but in legal terms, it's a guillotine. It means that if you fail to perform your obligations by the exact date specified in the contract, you are in breach. There is no grace period, no wiggle room. So let's say your closing is set for Friday, and a time is of the essence clause is in effect. On Thursday, your bank has a last-minute paperwork issue and says the funds won't be ready until Monday morning. It's just 1 business day. No big deal, right? Wrong. Because of those 4 words on Friday at 5:01 p.m., you are officially in breach of contract. The seller can legally terminate the deal, keep your entire 5-figure deposit, and sell the house to someone else. You've lost your dream home and your life savings because of a one-day delay that wasn't even your fault. A lawyer foresees this. They will fight to strike that clause from the contract, or they'll add protective language that allows for reasonable, good faith delays in financing without triggering a catastrophic default. They build a buffer zone around your money. This brings up the fundamental difference between a real estate agent and a real estate lawyer. A great agent is a market expert, a negotiator, and a salesperson. Their primary function is to bring buyers and sellers together and get a deal to the finish line. They are absolutely vital, but they are not licensed to give legal advice. In fact, if they do, they could lose their license. They use standard fill-in-the-blank contracts that are designed to be neutral and serve the transaction itself. A lawyer's sole fiduciary duty is to you and you alone. Their job isn't to make sure the deal closes. Their job is to protect you, even if it means advising you to walk away from a deal that feels perfect. They take that standard contract and transform it from a generic template into a personalized shield, custom-built to defend your interests. An agent helps you find the house. A lawyer makes sure you can actually keep it, without any devastating surprises. So, given all these potential disasters, why doesn't every single person in America use a lawyer? The answer is fascinating, and it's something most home buyers never learn until it's too late. It's because the United States doesn't have one system for buying a house. It has two. The country is split down the middle into what are known as attorney states and escrow states. In attorney states, mostly concentrated on the East Coast like New York, Massachusetts, and Georgia, the law essentially requires that a lawyer be involved in the transaction, usually to handle the closing. It's just part of the process. But in the rest of the country, the majority of states are escrow states or title states, like California, Texas, Florida, and Arizona. In these states, the closing is handled by a neutral third party, an escrow or title company. And in these states, hiring your own lawyer is completely optional. The system is set up to function without one. This is the critical divide. This is why your cousin in New Jersey tells you her lawyer handled everything, while your friend in Colorado has never even spoken to one. But here's the most important question this raises, the one that should keep you up at night if you're buying in an escrow state. Just because the system is designed so you can do it without a lawyer, does that mean you should? What happens when you're in a state where you're left to navigate those minefields on your own, where the title agent works for the transaction itself, not for you? That's where the real risks multiply. That's where the dream of homeownership can turn into a legal and financial nightmare with terrifying speed. And these nightmares aren't hypothetical, black swan events that happen to one unlucky person in a million. They happen every single day in cities and towns all across America. They happen to smart people, to careful people who simply didn't know what they didn't know. Let's talk about the contract itself. The purchase agreement. Your real estate agent, who is likely fantastic at finding homes and negotiating price, hands you a 12-page, boilerplate document. It's the standard state-approved contract. It looks official, feels safe, but standard doesn't mean designed to protect you. Standard means designed to be neutral enough to get a deal done. It's filled with clauses that can become devastating traps if you don't understand their full implication. Imagine this scenario. A young couple, let's call them Mark and Sarah, are buying their first home. It's a bit of a fixer-upper, sold as is. Their inspection report flags a few things. Some old wiring, a leaky faucet, nothing that seems like a deal-breaker. The seller offers a $2,000 credit at closing, and they happily accept. They sign the papers, get the keys, and start their new life. A month later, after the first heavy rainstorm, the basement floods. Not just a little dampness, but a full-blown indoor swimming pool. They call in a contractor who discovers a massive crack in the foundation, cleverly hidden behind a newly built drywall frame. The repair cost? $45,000. Their life savings gone. They're furious. They call their agent, who says, "I'm so sorry, but you bought it as a..." They look at their contract. Sure enough, the as-is clause essentially waives their right to complain about defects found after closing. But here's the kicker. In their state, even with an as-is clause, a seller has a legal duty to disclose any known material defects. And it turns out the seller absolutely knew. A neighbor later mentions the previous owner had 3 different foundation companies give them quotes the year before. So they have a case, right? Yes, but now they have to hire a litigation attorney at $400 an hour to sue the seller. The lawsuit will take a year, maybe 2. It will be emotionally draining and financially ruinous. All because of one little clause and a hidden crack. Now let's rewind. What if Mark and Sarah had spent $1,500 on a real estate attorney from the start? The attorney would have read that same as-is clause and immediately explained the risks. They wouldn't have just said, "This is standard." They would have said, "This clause heavily favors the seller. It limits your recourse. Given the age of the house and the inspection findings, I recommend we draft a custom addendum." This addendum, this simple one-page document, could have stated that the seller warrants they have no knowledge of any latent defects, including issues with the foundation or water intrusion, and that this warranty survives the closing. Faced with signing that, the seller has two choices: refuse, which is a massive red flag that they're hiding something, or sign it. If they sign it and lie, the subsequent lawsuit becomes a slam-dunk case of contractual fraud, not a murky he said, she said battle. That $1,500 fee could have saved them $45,000 in repairs and tens of thousands more in legal fees. It would have turned a potential catastrophe into a simple negotiation or a decision to walk away. That's just the contract. The real ghosts often hide in a property's history, in the chain of title. The title company's job is to search public records and issue an insurance policy, but they don't dig into the human drama behind the deeds. Consider the case of a man buying a beautiful lakefront property. It was being sold as part of an estate. The seller was the sole daughter of the deceased owner. The title search came back clean. The daughter was the legal heir, the deed was transferred, and the title insurance policy was issued. A year later, the man decides to build a new boat dock. As soon as the permits are filed, he gets a certified letter. It's from a lawyer representing a man he's never heard of, the deceased owner's illegitimate son, who had been completely left out of the will but, under state law, was still entitled to a portion of the estate. Now, his ownership of the property is under a legal cloud. The title insurance company gets involved, of course. That's what it's for. But their goal is to resolve the claim for the least amount of money, not necessarily to make him whole in the way he wants. He's now a pawn in a bitter family legal battle. He can't sell the property. He can't refinance it. He can't build his dock. His dream home has become a legal prison. All because of a family secret buried deeper than a standard title search would ever go. How would an attorney have helped? A good real estate lawyer, seeing the sale was from an estate, would have immediately gone into a higher state of alert. They would have asked for more than just the death certificate and the will. They would have requested the full probate court filings. They would have questioned the timeline. They would have asked the seller to sign an affidavit, under penalty of perjury, attesting that there are no other known or potential heirs. They would have acted as a skeptical investigator, not just a processor of paperwork. They would have sniffed out the risk and advised their client on how to mitigate it, perhaps by demanding a larger indemnity from the seller or requiring a court order that explicitly clears the title of any future claims. And then there's the modern-day minefield: homeowners associations, or HOAs. You think you're just buying a house, but what you're really buying into is a private government with its own laws, its own courts, and its own power to fine you and even foreclose on your home. When you're in escrow, you'll be handed a stack of documents the size of a phone book: the HOA covenants, conditions, and restrictions, or CC&RS, plus the budget, meeting minutes, and reserve study. Your agent will tell you to read them, but are you really going to? Are you going to read 200 pages of dense legalese written by attorneys for attorneys? Of course not. You'll skim it, see the rules about trash cans and lawn maintenance, and assume the rest is standard boilerplate. This is a colossal mistake. Buried in those pages could be a clause preventing you from parking your work truck in your own driveway, or a rule forbidding the exact type of fence you need for your dog. Or worst of all, you might find clues in the financial documents and meeting minutes that the HOA is in serious trouble. You might see that the reserve funds for major repairs, like replacing the roof on the community clubhouse or repaving the private roads, are dangerously low. And then, 6 months after you move in, you get the letter: a special assessment has been levied on every homeowner to cover a $50,000 shortfall for a new roof. Your share is an immediate, unplanned $5,000 bill. And it's not optional. If you don't pay, they can put a lien on your house. A real estate attorney eats those documents for breakfast. It is literally their job to read the fine print. They will analyze the reserve study. They will spot the line item in the budget that shows insurance costs have tripled because of a pending lawsuit against the HOA. They will read the meeting minutes where the board has been arguing for a year about the crumbling retaining wall that's about to fail. They are trained to see the financial and legal red flags that are invisible to the untrained eye. They can tell you, this HOA is a financial time bomb. You should run from this deal. That advice alone is worth 10 times their fee. In all of these cases, the contract trap, the title ghost, the HOA hydra, the problem is the same. The buyer is the only person in the transaction without an expert looking out for their interests and their interests alone. The agent wants the commission. The lender wants the loan origination fee. The title officer wants the policy premium. Their success is tied to the deal closing. An attorney is the only one you pay to tell you when a deal is so bad that you should walk away and be glad you did. Their success is tied to your long-term safety and security. So now that we've established who is truly in your corner, let's get into the nuts and bolts of where this all plays out. Because the first and most important answer to the question, do I need a lawyer? Isn't a matter of opinion. It's a matter of geography. The United States real estate market is not one single entity. It's a patchwork of 50 different state systems, and they generally fall into two major categories: what are known as attorney states and title company states. Understanding which one you live in is the first step to making an informed decision. Let's start with the attorney states. As the name implies, these are states where state law or long-standing legal custom requires a real estate attorney to be involved in the home buying process, particularly at the closing. We're talking about places like New York, Massachusetts, Georgia, South Carolina, North Carolina, Delaware, and several others. If you're buying a house in one of these states, the question is already answered for you. You don't have a choice. You need a lawyer. But why? Why do these states mandate it? It boils down to a fundamental belief that the transfer of real property, a piece of the earth, is a profoundly significant legal act. It's not like buying a car or a television. It's a complex transaction involving deeds, titles, liens, and contracts that can have legal consequences for generations. These states decided that this process is so legally intricate that it constitutes the practice of law, and therefore, a licensed attorney must be involved to protect the public. In these states, the attorney isn't just a glorified proofreader who shows up at the end. They are the central quarterback of the transaction. After your offer is accepted, your agent will immediately tell you to hire an attorney. That lawyer will then draft or meticulously review the purchase contract, negotiate terms on your behalf, and advise you on inspection issues. They will conduct or oversee the title search, examining the chain of ownership for any defects, clouds, or hidden claims. They'll review your mortgage documents from the lender to ensure the terms match what you were promised. And crucially, they will often conduct the closing themselves, sitting you down at the table and explaining every single one of the dozens of documents you're about to sign. They are your guide, your shield, and your legal representative from contract to closing. The system is designed with your legal protection built right in. Now let's flip the coin and look at the other side. Title company states, also known as escrow states. This group includes a huge portion of the country, including massive markets like California, Texas, Florida, Arizona, Washington, and Nevada. In these states, the closing process is typically handled by a title company or an escrow officer. There is no legal requirement to have an attorney involved. The role of the title company is to act as a neutral third party. Think of them as a referee. Their job is not to represent the buyer or the seller, but to represent the integrity of the deal itself. They are given the purchase agreement, the rulebook, and their job is to make sure both sides follow it. They hold the buyer's earnest money in an escrow account. They order a title search and issue a title insurance policy. They gather all the necessary documents from the buyer, the seller, and the lender. They prepare the final settlement statement, showing where every single penny is going. And once everything is in order and all conditions are met, they facilitate the final exchange of money and property. They do this job very, very well. They are efficient, professional, and essential to the functioning of real estate in these states. But here's the critical distinction, the one that so many buyers miss. The escrow officer cannot give you legal advice. It's not that they don't want to, they are legally prohibited from doing so. Their role is to execute the instructions in the contract, not to interpret them for you or advise you on whether those instructions are in your best interest. Their loyalty is to the successful closing of the transaction, as outlined in the paperwork. If you have a question about a clause in the contract, or if you're worried about a strange easement you see on the title report, their answer will and must be, "I can't advise you on that." You would need to consult with an attorney. They are a facilitator, not an advocate. To make this crystal clear, let's imagine two families buying their first home. First, meet the Jacksons buying a house in Connecticut, an attorney state. Their offer is accepted. Their agent gives them a list of 3 local real estate attorneys. They hire one named Sarah. Sarah immediately gets the contract and sees a clause the seller added about the property being sold as is. She calls the Jacksons and explains exactly what that means legally, that they'll have very little recourse if they discover a major problem after closing. She recommends adding an addendum that clarifies the as-is clause only applies to cosmetic issues, not major structural, environmental, or safety defects found during inspection. The seller's attorney agrees. A week later, the title search Sarah conducts uncovers an old, undischarged lien from a solar panel company that the previous owner used 10 years ago. The company is now out of business. This is a cloud on the title that could prevent the Jacksons from ever selling the house in the future. Sarah spends the next 2 weeks tracking down the successor company and getting the legal releases needed to clear the title. The Jacksons barely even know this is happening in the background. At closing, Sarah sits with them for an hour, explaining the deed, the mortgage note, and the closing disclosure line by line. The Jacksons sign with complete confidence, knowing a legal expert has guided and protected them every step of the way. Now let's meet the Changs buying a very similar house in Colorado, a title company state. Their offer is accepted. The contract is sent to an escrow company. An escrow officer, David, opens the file. He's fantastic, incredibly organized and a great communicator. He sends them a preliminary title report. The Changs are reading through it, and on page 12, they see a restrictive covenant from 1962 that says no temporary structures can be placed on the property. Mr. Chung plans to build a large high-end workshop shed in the backyard. Is that a temporary structure? He calls David the escrow officer. David politely and correctly explains, "Sir, I can show you where that covenant is recorded in the county records, but I can't interpret what it legally means for your shed. I'm not an attorney." The Changs now have a choice. They can either ignore it and hope for the best, or they can pause the entire process, scramble to find a real estate attorney they've never met, pay them to get up to speed on the entire transaction, and have them issue a legal opinion on a 60-year-old covenant, all while the clock on their financing and closing deadlines is ticking. Do you see the difference? It's not that one system is inherently better than the other. Both result in millions of successful home sales every year. The difference is in the default setting for legal protection. In an attorney state, that protection is built in, a standard feature of the process. In a title company state, it's an optional add-on. The responsibility shifts entirely onto you, the buyer, to recognize when you need legal help and to go out and find it. So the first answer to our big question isn't a matter of opinion, it's a matter of geography. But what if you're like the Changs? What if you're in a state like Colorado or Texas or California where you have a choice? That's when the real decision-making begins, because just because you can go it alone doesn't always mean you should. So let's talk about those situations. Let's call them the red flag scenarios. These are the moments in a home buying journey, even in states like Texas or California, where the small upfront cost of a lawyer can suddenly feel like the best insurance policy you've ever purchased. Think of it this way: your real estate agent is your guide up the mountain. They know the path, the best times to climb, and how to negotiate the common terrain. But a lawyer? A lawyer is the emergency medic and survival expert you bring along. You might not need them. The climb might be perfectly smooth. But if you slip, if a storm rolls in unexpectedly, they are the one person who can save you from a catastrophic fall. Most real estate transactions are standard. They use boilerplate contracts that have been tested and refined over decades. For a straightforward purchase of a single-family home from a typical seller, your agent can handle these forms expertly. They are trained to fill in the blanks, manage deadlines, and use standard addendums for common situations like inspections or financing contingencies. And 90% of the time, that's all you need. The problem is, you never know if you're in the 90% or the 10% until it's too late. The line is drawn at one critical point. A real estate agent can explain what the contract says, but they cannot give you legal advice on what it means for you, or how to change it to better protect your specific interests. They can't draft custom legal language from scratch. Doing so would be considered the unauthorized practice of law, and it could cost them their license. So when a situation pops up that isn't covered by a standard, pre-approved form, you're venturing into uncharted territory. Let's imagine a couple, we'll call them the Millers. They're buying a charming older house in a beautiful tree-lined suburb of Austin, Texas. It's a choice state. No lawyer required. Their agent is a rock star, and everything is going smoothly. They get to the inspection, and the inspector points out the magnificent 100-year-old oak tree in the backyard. It's one of the reasons they fell in love with the house. But he notes that one of its massive limbs extends way over the neighbor's fence, hanging directly above their garage. The inspector, doing his due diligence, simply notes, "Recommend consulting an arborist." The Millers mention it to their agent. The agent, trying to be helpful, says, "Yeah, that's common around here. We can ask the seller for a credit to have it trimmed." Seems like a simple solution, but the Millers have a nagging feeling. What if the tree is sick? What if a storm hits before they get a chance to trim it? What is their legal liability the moment they sign those closing papers? They ask their agent, "Are we responsible if that branch falls and crushes our new neighbor's car?" And that is the moment the agent has to pump the brakes. They can't answer that. It's a legal question. They can't advise on liability, on local ordinances regarding trees, or on the legal ramifications of a potential property damage claim. They can only point to the standard contract, which likely doesn't have a specific clause for neighbor's garage potentially being flattened by your majestic but terrifying oak tree. The Millers are on a tight budget. The thought of spending another $1,500 on a lawyer for what seems like a minor issue feels like a waste. They decide to just ask the sellers for a $500 credit for a tree trimmer and hope for the best. They close on the house, excited for their new life. 3 months later, a classic Texas thunderstorm rolls through. A crack of lightning, a gust of wind, and that massive oak limb splits from the trunk and shears right through the neighbor's garage roof, destroying a vintage convertible they had been restoring. The neighbors are, understandably, furious. And then they drop the bombshell. They had sent a certified letter to the previous owner a year ago, with a report from their own arborist, stating that the limb was a hazard and needed to be removed. The seller never disclosed this. The Millers are now facing a lawsuit. Their new homeowner's insurance is fighting the claim, arguing it was a pre-existing, known condition that wasn't disclosed. The Millers are on the hook for potentially $50,000 in damages, not to mention the legal fees to defend themselves. That $1,500 they saved by not hiring a lawyer now seems like a rounding error in the face of a financial and emotional disaster. So what would a lawyer have done? A lawyer, hearing about the tree, would have immediately seen it not as a maintenance issue, but as a liability issue. Their brain is wired to spot risk. They would have advised the Millers to pause. They would have drafted a specific, custom addendum to the purchase contract. This addendum wouldn't have just asked for a credit. It might have required the seller to provide a warranty that they had received no prior complaints about the tree. It might have demanded the seller have the tree professionally evaluated and trimmed by a certified and insured arborist before closing. It would have required the seller to provide proof of the work. More importantly, the lawyer would have asked the right questions that go beyond the surface. They'd ask, "Has the neighbor ever complained about this tree?" In writing. This simple question could have uncovered that certified letter, completely changing the negotiation. The lawyer could have then insisted the seller's homeowner's insurance cover the removal, or place a significant amount of money in escrow to cover any potential damages for a period after closing. They would have transformed a vague, hopeful solution into a legally binding shield that protected the Millers from the exact disaster that unfolded. That is the difference. It's the difference between hoping for the best and being legally prepared for the worst. The Millers tree is a perfect example of a red flag scenario, but there are so many others. Are you buying a property that's part of an estate sale because the owner passed away? A lawyer can navigate the complexities of probate court to ensure the sellers actually have the legal right to sell it to you. Are you buying a foreclosure or a short sale? A lawyer will scrutinize the title work for hidden liens from contractors, unpaid taxes, or second mortgages that the bank forgot to mention, which could become your problem after closing. Is the property in a flood zone or have a history of environmental issues like an old buried oil tank? A lawyer can help you understand your long-term risks and negotiate protections. Are you buying a home with a tenant already living in it? Your agent can give you the lease, but a lawyer can analyze it and advise you on the complex local and state laws governing tenants' rights and the eviction process. What if the survey comes back and shows the neighbor's fence is actually 2 feet on your property? That's called an encroachment. An agent can't solve that. A lawyer can negotiate a formal easement or a boundary line agreement to prevent a massive dispute down the road. Anytime a transaction deviates from the absolute norm, the red flag should go up. If you're dealing with a difficult seller buying from a corporation or an LLC, if the house has unpermitted additions, if you're in a contentious multi-offer situation where contracts are flying back and forth with strange clauses, these are all signals. These are the moments where you need a specialist in legal risk. You're not just buying wood, drywall, and land. You are buying a legal bundle of rights, as they call it in law school, and you want to be damn sure that bundle is complete, clear, and doesn't have a ticking time bomb hidden inside. This isn't about distrusting your real estate agent. In fact, the best agents are often the first to say, "This is outside my area of expertise. You should really consult an attorney." They understand the boundaries of their profession and want to protect their clients. The agent and the lawyer aren't adversaries. They are two essential specialists on your personal home buying team. Your agent is your strategist for the market. Your lawyer is your strategist for the contract. So you've identified a red flag. You've heard the Miller story and you don't want to live it. You've decided to hire a lawyer. But what happens next? What are you actually paying for? When you hand over that check, what specific concrete actions does that lawyer take to protect you, from the moment you sign the contract to the second the keys are in your hand? We're about to pull back the curtain on the entire legal process. Alright, let's start with the very first thing your lawyer does. Often within hours of you saying, "We have a deal." It's called the attorney review. In many states, after you and the seller sign that initial purchase agreement, the one your real estate agent probably filled out from a template, a clock starts ticking. It's usually a 3 to 5 day window where the lawyers for both the buyer and the seller can review, modify, or even completely cancel the contract. This isn't just a quick once-over. This is the legal equivalent of a bomb squad examining a suspicious package. The standard contract your agent uses? It's a fantastic starting point. It's a one-size-fits-all t-shirt, but your transaction, your life savings, your future home, that deserves a custom-tailored suit. Your lawyer is the master tailor. They start with the contingencies. These are your escape hatches. The most common are the inspection, mortgage, and appraisal contingencies. The standard contract will say something like, "Buyer has 10 days to do an inspection." Your lawyer reads that and thinks, "Not good enough." They'll redraft it to be ironclad. For example, they'll specify exactly what happens if the inspection reveals problems. Does the seller have to fix them? Can you demand a credit? Can you walk away and get your deposit back without a fight? Your lawyer defines the terms of engagement. They'll write in language that says if the inspection reveals defects costing more than, say, $1,000 to repair, you have the unilateral right to terminate the contract and receive a full, immediate refund of your earnest money. Without that specific language, you could find yourself in a month-long argument over a leaky roof, with your deposit held hostage. Then there's the mortgage contingency. This is massive. What if you get pre-approved, find a house, sign the contract, and then the bank's final underwriter denies your loan 2 days before closing? It happens more than you think. A standard contract might be vague. Your lawyer adds clauses that protect you, stating that if you are unable to secure a mortgage commitment by a specific date, despite a good faith effort, the contract is void and you get your deposit back. They protect you from losing your life savings because of a last-minute decision by a faceless bank underwriter. They build you a bulletproof exit strategy. Next, your lawyer becomes a historian digging into something called the title. Think of the property's title as its life story. Your lawyer's job is to read that story and make sure there are no hidden villains or tragic plot twists. They order what's called a title search from a specialized company. This search scours public records for any clouds on the title. These clouds can be anything. An old unpaid mortgage from a previous owner that was never formally discharged. A tax lien from the IRS because the seller didn't pay their taxes for 3 years. A claim from a contractor who put a new roof on 5 years ago and never got paid. Or the most terrifying, a long-lost heir from a will 2 generations ago who technically still has a claim to a piece of the property. The title company finds these issues. Your lawyer solves them. They see a lien from an old contractor? They don't just tell you about it. They contact the seller's attorney and issue a formal demand. You must pay this lien and provide proof of satisfaction before closing, or the deal is off. They see a boundary issue or a strange easement, which is a right for someone else to use your property, like a utility company having the right to dig up your backyard, and they explain the real-world implications to you. They might discover a shared driveway agreement with a neighbor that requires you to pay for half the snow removal for the next 50 years. These are things that would never come up in a home inspection. These are the invisible traps buried in the legal DNA of the property, and your lawyer is the only one with the equipment to detect and disarm them. Let me tell you a quick, true story. A couple in New Jersey was buying their dream home. They skipped the lawyer to save a few bucks. The title search came back clean. They closed, moved in, and decided to build a pool in the backyard. When they filed the permit, the town denied it. Why? Because a massive undocumented municipal sewer easement ran directly through the middle of their yard. It wasn't recorded properly in the main deed file, but it was in the deeper municipal records. They could never build their pool. They couldn't even build a deck or plant a large tree there. Their backyard was partially unusable forever. A good real estate lawyer would have insisted on a full survey and cross-referenced it with municipal records, uncovering that easement before they ever signed the final papers. That saved $2,000 cost them tens of thousands in property value and a shattered dream. The lawyer's investigation doesn't stop there. They perform what are called municipal searches. They check with the town building department for any open permits. You see, if the previous owner took out a permit to finish the basement but never got the final inspection, that open permit is now your problem. The town could force you to tear out the drywall to inspect the wiring, or even undo the entire renovation, all at your expense. They also check for code violations. Is there a fine against the property for an overgrown lawn or an illegal fence? If you close on that house, that fine becomes your bill to pay. Your lawyer finds these things and forces the seller to resolve them before you own the problem. And then comes the negotiation. This is where the lawyer truly earns their fee. Let's go back to the home inspection. Your inspector finds a list of issues. Some minor, some significant. There's evidence of old water damage in the attic, the furnace is 25 years old, and a few electrical outlets aren't grounded. As a buyer, your conversation with the seller can get emotional and awkward. You feel like you're nickel-and-diming them. They feel like you're insulting their home. When a lawyer gets involved, all that emotion is stripped away. It becomes a business transaction between two professionals. You don't call the seller. You call your lawyer. You forward them the inspection report. Your lawyer then drafts a formal, dispassionate letter to the seller's attorney. It doesn't say, "Your furnace is junk." It says, "Pursuant to Section 12 of the purchase agreement, the buyer's inspection has revealed material defects, specifically the HVAC system, which has exceeded its stated operational lifespan. We have obtained an estimate for replacement at a cost of $8,000. We hereby request a credit in this amount to be issued to the buyer at closing." It's professional. It's based on the contract you both signed. And it is infinitely more effective. The seller's attorney isn't going to argue about feelings. They're going to look at the contractual obligation and the financial reality. This legal buffer prevents deals from falling apart over pride and emotion, and it often results in you getting significant concessions you would have been too uncomfortable to ask for yourself. That one negotiation over the furnace or the roof can often save you 5 to 10 times the cost of your lawyer's entire fee. So the lawyer has dissected the contract, built in your escape hatches, investigated the property's secret history, cleared any legal bombs from the title, and negotiated thousands of dollars in credits on your behalf. The path looks clear. The closing date is set. You're ready to sign the papers and get the keys. Feels like you've crossed the finish line. But the truth is, the most critical and financially dangerous part of the entire process is still ahead. What happens in that final hour at the closing table is where a simple mistake, a single overlooked fee on a long document, can cost you dearly for years to come. And the most important document you'll be asked to sign is almost never the one you think it is. It's not the deed, the piece of paper that officially transfers ownership of the property from them to you. It's not the mortgage note, the legally binding document where you promise to pay back a life-altering sum of money over the next 30 years. No, the most dangerous, most critical, and most frequently misunderstood document you will sign at the closing table is a 5-page form created by the federal government. It's called the Closing Disclosure, or the CD, and on the surface it looks painfully boring. It's a dense grid of numbers, line items, and financial jargon. It looks like an accountant's spreadsheet, and that's exactly why it's so treacherous. This document is supposed to be the final, transparent accounting of every single penny in your transaction. Every fee, every credit, every tax proration, every dollar changing hands is listed right here. Your down payment, your loan amount, your closing costs, your prepaid expenses, it's all there. In theory, this is a good thing. It was created after the 2008 financial crisis to prevent lenders from surprising buyers with last-minute fees. But in practice, it's a minefield. You are legally supposed to receive it 3 days before closing to review. But in the real world, last-minute changes often lead to a revised version being printed out right there at the closing table, and you're expected to review, understand, and sign it in minutes with the seller's 2 real estate agents and a closing agent all staring at you, tapping their pens, waiting to get paid. The pressure is immense, and your brain, overwhelmed with excitement and anxiety, sees a final cash to close number that looks about right. So you sign. Let me tell you about a couple, we'll call them David and Emily. They were buying their first home. A small starter house in a decent suburb. They had saved for years. They did everything right. They got pre-approved, found a great agent, and negotiated a fair price. They were smart, educated people. They decided to hire a real estate attorney, mostly because their state required it, but they saw it as just another box to check, another fee to pay. At the closing, they sat down, a mountain of paperwork in front of them. The closing agent, a friendly but clearly busy person, started sliding documents over. Sign here, initial here, and here. When the closing disclosure came, David glanced at the bottom line. The cash he needed to bring was about $2,000 more than the last estimate he'd seen. He felt a small knot in his stomach, but he brushed it aside. Maybe he'd misremembered. His agent glanced at it, nodded, and said, "Looks standard." Standard. That's the word that lulls you into a false sense of security. But their lawyer, a quiet man in his late 50s, held up a hand. "One moment, please." He didn't say it loudly, but the room went silent. The friendly closing agent's smile tightened just a fraction. The lawyer pulled out David and Emily's original loan estimate, the document the lender gave them at the very beginning of the process. He put it side by side with the closing disclosure. He then pulled out a simple pocket calculator. The only sound in the room for the next 2 minutes was the soft click-click-click of the calculator keys. He ran his finger down one page, then the other. He circled a number, then another. Finally, he looked up, not at David and Emily, but directly at the closing agent. "There seems to be a discrepancy here," he said calmly. He pointed to a line item, lender origination fee. On the closing disclosure, the lender was charging them 1% of the loan amount. But on the original loan estimate they had signed, the lender had agreed to a fee of 0.5%, a 0.5% difference. On their $300,000 loan, that was a $1,500 mistake. David's jaw tightened. Emily's eyes went wide. Their agent looked embarrassed. He'd missed it completely. The lawyer wasn't done. He pointed to another line. Title services, lender's title policy. The fee was $400 higher than the quote the title company had provided a week earlier. Another mistake. Then he pointed to the property tax prorations. The calculation assumed the seller had paid their taxes through the end of the month, when they had only paid through the 15th. The error meant David and Emily were about to give the seller a credit for taxes the seller had never actually paid. It was another $650. Total cost of these standard-looking mistakes? $2,550. An entire mortgage payment, almost. Money that would have simply vanished from their bank account, absorbed into the transaction, never to be seen again if they had just signed. The closing agent, now flustered, made a phone call to the lender. There was a hushed, tense conversation. The lender's representative initially claimed the fees were correct, but the lawyer had the original signed loan estimate. It was black and white. There was no argument. After 15 minutes of back and forth, the lender magically found a way to correct the clerical error. The title company, when called, did the same. A new closing disclosure was printed. The cash-to-close number was now $2,500 lower. David and Emily signed, their hands slightly shaking, not from nerves anymore, but from the adrenaline of a narrowly avoided financial hit. The lawyer's fee for the entire transaction was $1,200. By spending that $1,200, they saved more than double that amount in a single 10-minute review at the closing table. This story isn't a rare, one-in-a-million exception. It is the bread and butter of what a real estate attorney does. They are the only person in that room whose sole undivided fiduciary duty is to protect you and your money. Your real estate agent wants the deal to close so they can get their commission. The lender's agent wants the deal to close to get their commission. The closing agent works for the title company and just wants to get the file off their desk. They are not bad people, but their financial interests are tied to the closing itself, not necessarily to the perfection of the details within it. The lawyer is different. Their value is in finding the problems. They are your professional skeptic, your financial bodyguard. They scrutinize every number on that closing disclosure, comparing it against every prior document, looking for the tiny, expensive deviations that everyone else is incentivized to overlook. They check the deed to ensure your names are spelled correctly, and that you're taking title in the way that's best for your financial situation. They check for hidden clauses in the mortgage documents, like unfair prepayment penalties. They are the final line of defense against the costly, systemic sloppiness that can plague a complex financial transaction. And this is where the game is truly won or lost. Let me tell you about a couple, Mark and Jessica. They were buying their first home, a beautiful little bungalow just outside the city. They'd done everything by the book, saved for years, got their pre-approval, found a great agent, and negotiated a fair price. They were 2 weeks from closing and everything seemed perfect. Then they got a call from their agent. The seller, an elderly woman moving into a retirement community, had passed away unexpectedly. Suddenly, their straightforward purchase was thrown into chaos. The house was now part of an estate. The seller's children, who were scattered across the country and didn't all get along, were now the decision makers. One son wanted to sell quickly as agreed. A daughter, who had an emotional attachment to the home, suddenly wanted to back out. Another son thought they could get more money and wanted to put the house back on the market. Mark and Jessica were in limbo. Their mortgage rate lock was about to expire. They had already given notice on their apartment. Their lives were packed in boxes, and the dream home they were days away from owning was now tangled in a family drama and a complex probate court process. Their real estate agent, while sympathetic, was completely out of his depth. He's a salesperson, not an estate law expert. He advised them to just wait and hope for the best. But hope isn't a strategy when your life savings and housing are on the line. This is the exact moment where the value of a real estate attorney becomes crystal clear. Panicked, Mark and Jessica hired one. The first thing their lawyer did was calm them down. He explained the probate process in simple terms. He wasn't just a document reviewer. He was now their strategist and crisis manager. He immediately contacted the attorney representing the seller's estate. Instead of emotional, panicked phone calls from agents and buyers, it was now a professional lawyer-to-lawyer conversation. Their attorney laid out the legal reality. Mark and Jessica had a legally binding purchase agreement. The estate was obligated to honor it. He filed the necessary legal notices with the probate court to protect their claim to the property, effectively preventing the heirs from selling it to someone else. He negotiated a formal extension to their contract, which he then used to get their lender to extend their rate lock. He navigated the family squabbles not by appealing to emotion, but by citing contract law and the legal consequences of a breach. 2 months later, 2 months that would have been an agonizing, uncertain nightmare without legal help, Mark and Jessica closed on their home. The attorney's fee was about $1,500. But what did they buy for that money? They bought their house. They bought the low interest rate they had locked in. They avoided losing their earnest money deposit. They avoided the cost and chaos of having to find a new place to live with no notice. They bought certainty in the face of total chaos. Their lawyer wasn't just another closing cost. He was the reason the closing happened at all. This is the hidden value. We often think of lawyers as a cost center, another fee to be paid. But that's the wrong frame. A good real estate attorney is a profit center. They don't cost you money. They save you money. They save you from the $5,000 surprise property line dispute. They save you from the $10,000 undisclosed lien from the seller's unpaid contractor. They save you from the $15,000 special assessment the condo board forgot to mention was coming next year. The average fee for a real estate lawyer is a tiny fraction, often less than half of 1%, of the home's purchase price. Think about that. You pay the real estate agents a commission of 5 to 6%, a cost that is baked into the price of the home. They are paid to get the deal done. Your lawyer is paid a small flat fee to make sure the deal is done right. Their fee is the single greatest bargain in the entire real estate transaction. It's the cheapest insurance policy you will ever buy on the most expensive asset you will ever own. We buy insurance for our cars, our health, our lives. We do it to protect against unforeseen catastrophic events. Why then would we gamble on the single largest financial transaction of our lives without it? Going into a real estate deal without your own legal counsel is like agreeing to play a high-stakes poker game where everyone else at the table knows the rules better than you do, and you're the one putting up all the money. So let's bring it all together. Do you need a real estate lawyer? If you live in an attorney state, the answer is yes, it's legally required. The system is designed for it. But for the rest of the country, the question isn't about necessity, it's about wisdom. It's about risk management. If your transaction is anything other than a standard, single-family home purchase from a traditional seller, the answer leans heavily toward yes. Buying a foreclosure, a short sale, a property from an estate, or a home with known structural or title issues. You absolutely want a lawyer. Buying new construction from a developer who hands you a 150-page, one-sided contract? You'd be insane not to have an attorney review it. Are you an out-of-state buyer? Or is there anything about the deal that makes you feel uneasy or pressured? Get a lawyer. That feeling in your gut is your warning system. And a lawyer is the expert you call to investigate. But even if your deal seems perfectly simple, perfectly straightforward, the value is still immense. Because the most dangerous risks are the ones you can't see. The agent works for the commission. The lender works for the bank. The title company works to issue a policy. Your attorney works for you. They are the only person in the entire process whose sole, undivided fiduciary duty is to protect your interests. They are your personal advocate, your legal guardian, your professional skeptic who is paid to ask the tough questions and find the problems before they find you. In the end, buying a home is the quintessential American dream. It's a symbol of stability, of building a future, of putting down roots. But the path to that dream is paved with dense legal contracts, financial complexities, and potential pitfalls that can turn the dream into a nightmare. You have a team to help you. Your agent finds the house, your loan officer provides the money. But the lawyer is the one who ensures the foundation you're building your future on is solid rock, not shifting sand. The deed to your home is more than just a piece of paper. It is the legal embodiment of your hard work, your savings, and your future. Protecting that document, and the entire process that leads to it, isn't an extravagance. It's the final, most crucial piece of due diligence. So the question we started with, do you really need a real estate lawyer? Is the wrong question. A better question is, why would you risk not having one? When you are signing your name to the biggest financial commitment of your life, when you are navigating a process with so many moving parts and competing interests, can you truly afford to be the least protected person in the room?